Thank you, Honourable Member. As many? The Chair recognizes the Honourable Member for long.
Madam Speaker, I think Centerville has some other plans ahead. Madam Speaker, I rise on behalf of the great people of Long Island, the hard-working, wonderful, supportive people from whence I came. Madam Speaker, I begin by acknowledging a few people on the island, beginning with my grandfather. And he turned 90 about a week or so ago. I want to acknowledge him. He's grew up with him. He's a great man of God, faithful, strong, and tells me today that he could still beat me running, and I would not challenge him because he might. Madam Speaker, I want to also extend condolences to the family of Anthony Nine Adderley. Nine is a resident of Burnt Ground, Long Island. Nine came to Nassau, I think it was on the weekend past or so, apparently to get some medical assistance. And I understand that Nine was the victim of a hit-and-run accident. The person didn't even stop. You know how cold and callous you must be as you can just run someone down and keep on going as if that wasn't a human being that you just killed. Madam Speaker, before I get into the meat of my contribution, I want to address a few issues in my constituency. Again, I call upon the government for its assistance with respect to roads. You know, we have a regatta coming up, and the roads remain in a state of disrepair. Potholes galore. The verges are now deteriorating. You're driving on roads where you're going into craters, changing tires, changing CV joints, suspensions, shocks, etc. And again, I call on the government to assist with ensuring that the people of Long Island, who also pay taxes to drive on these roads, have decent, drivable roads. Madam Speaker, a concern I continue to raise here is the lack of medication in the clinics, basic medication in the clinics in Long Island. Hypertension, medicine, diabetes, etc. And I continue, I won't speak to who might be saying these things to me in terms of the professionals, but I continue to get complaints about the lack of medication, adequate supply of medication in both of the main clinics, in Misc as well as in Sims. Madam Speaker, you know, I believe that I've been one of those persons who've spoken on trials by judges in the past, particularly as it relates to capital offenses or complex white-collar cases that could alleviate the need for jury trials, where accused persons would choose this option. I believe that this could help to decrease the backlog in cases that are waiting to be tried. However, I do, while saying that, have a bit of some reservations about trial by a single judge in the Supreme Court. Don't get me wrong, I think this is a step in the right direction, but I do have my reservations. I've always embraced trials by judges, but I have also been more inclined towards trials by a panel of judges. You know, a judge is typically well-versed in legal matters and has experience in evaluating evidence and applying the law, which can lead to informed and reasoned decisions. However, and then of course, you know, unlike a jury trial, you know, a judge is obligated and would be obligated to provide detailed reasons for why a certain verdict was arrived at, or why a certain course of action was taken. You know, today, as was stated by some of my colleagues earlier, you have jury trials where a jury renders a verdict, you know, why they did it, etc. Madam Speaker, you know, I agree. Jury trials can be, as a practitioner at the bar, who has been in the, who's practiced criminal law as well as on the civil and commercial side, I believe that jury trials can be time consuming and probably more expensive than trials involving judges. When you look at jury selection, that could be a process unto itself. And then, you know, you have strain on judicial resources that could relate to protecting jurors or sequestering a jury, etc. We know, Madam Speaker, that cases can be greatly impacted by a number of factors, from the number of witnesses being called to the availability of witnesses, to the availability of defense counsel, to jurors, to the backlog of cases, to a number of pre-trial applications and how complex those applications might be, to the need for medical and forensic report. We know a number of murder cases have been going forward because either the forensic report or some medical report had yet to be submitted. And in the Bahamas, a murder case cannot advance until the report is received from the pathologist. The pathologist report has to be in before a case can go forward. And then, of course, you have pre-trial adjournments for various reasons that might impact timing. Madam Speaker, you know, I'm happy to note that the constitutional right preserving Bahamians and residents of Bahamas' rights to a jury remain intact. Of course, I do not believe that the government had an appetite anyway to go to a constitutional referendum, because I can say without doubt that I believe that that would have been refused or denied. However, Madam Speaker, I believe that whilst we take this step today, greater effort, we should move to amend the Juries Act. That deserves further amendment as well. And I will speak to those amendments that I think should affect the Juries Act in a moment. But as it relates to juries, Madam Speaker, in the Caribbean, in the Bahamas, and the wider Caribbean, you know that we have these small populations. So there's a difficulty in assembling a diverse and impartial jury pool. You know, this can lead to concerns about bias and the lack of representation in terms of whether someone's white, black, Indian, etc. This can lead to lawyers having questions relating to those factors. There's the influence of politics as a reality. There's concern about political interference and how that could undermine the impartiality of jury trials. There's also the issues concerning the complexity of evidence. You know, some cases involve complex legal and technical evidence that may be challenging for some jurors to appreciate and fully understand, even as it relates to summation when the judge sums up a case and there are complex instructions to the jury. So these instructions might be so complex that a layperson not well versed in the law or not quite understanding of it might misinterpret some things, or there might be poorly formulated instructions or insufficient guidance from judges. We've seen many an appeal where a judge was heavily criticized by appeal justices for how they did a summation or their instructions to a jury, or the fact that there was insufficient guidance from the jury and it caused confusion and affected the deliberation process. And then, of course, Madam Speaker, there's the public perception and media influence. You know, many of us as lawyers, we worry about the impact of media coverage and public perception on jury trials. That's a reality. Media sensationalism and the prevalence of social media can exacerbate these concerns, making it difficult to ensure an impartial jury. And so there has to be, I believe, greater education and awareness needed to ensure that jurors understand their role and the their responsibility in the legal process. And of course, Madam Speaker, there's issues of intimidation, jury tampering, jurors facing harassment. These are all realities that arise when you think of jury trials. Difficulty in predicting outcomes, and limited feedback. As I stated earlier, unlike bench trials, where judges have to provide a detailed explanation for their decisions, jury verdicts may not always be accompanied by a comprehensive feedback. Lawyers may find it challenging to understand the reasoning behind a decision, and that's a reality. But what I said earlier, Madam Speaker, with respect to amendments to the Juries Act, notwithstanding today's bills, which are a step in the right direction, although I think I prefer a panel of judges, I think some of the amendments we should consider with respect to the Juries Act to concern the reformation of the jury selection process. We all know in the Bahamas how that process goes, those of us who practice at the bar. And so there are challenges with the jury selection process, as there's very limited information about potential jurors. In the United States, they go into void their session where they're able to question jurors, ask specific questions about them, their backgrounds, et cetera, et cetera. And so in the Bahamas, on the other hand, though, you have it where jurors are assigned numbers, and they have balls that they shake up in a raffle drum, and they take it out and call a number. The juror then goes into the box or into the jury seating area, and someone in the defense or the prosecution team could object, or the juror will say, hey, I've sent in a letter for whatever reason, or I'm unable to do it. The judge could accede to a request or not. And then of course, lawyers, that is, have limited challenges. So you only have about a few challenges to the jurors that might be assembled. And when you run out of those challenges, you can't challenge a juror any further. We have no ability in the Bahamas to question jurors, as is done in jurisdictions such as the United States. You see, that causes it to be a greater sense of fairness if lawyers are able to do so, and also allows lawyers to identify biases or any other concerns before jurors are empaneled. Madam Speaker, as it relates to jurors, there is a need for greater public education campaigns, a need to combat any form whatsoever of political interference or intimidation or otherwise. And of course, I believe that there should be post-trial and feedback processes that happen after certain jury trials. I verily believe that. Madam Speaker, overall though, bench trials, that is trials by judges, I believe, offer a degree of efficiency and expertise in decision making. And whilst that is the case, there's also some limitations there as well. My reservation, Madam Speaker, as it relates to trials by a single judge in the Supreme Court, has to do with the risk of bias. I mean, the reality is, despite efforts to remain impartial, judges may bring their own biases, experiences, and perspectives into the decision-making process. In the United States, for example, we see whenever the Democrats come in or the Republicans come in, there are a number of political appointments to the bench. That's just the reality of it. Okay, each side trying to get a certain number of judges on the U.S. Supreme Court, on various federal courts, various appeals courts, and so that can be a bit of a concern locally as well. Madam Speaker, one of the issues also in terms of having a single judge presiding over a case has to do with limited perspectives. A single judge may have a limited range of perspective and experiences as opposed or as compared to a panel of judges. where you have diverse perspectives sitting there, a panel of 3, for example. And then, of course, there's issues of checks and balances. You know, what a panel with 3 judges, they can check each other. They have that discussion. And they avoid judicial errors as well, more than likely. And there's an opportunity for alternate viewpoints and dissenting opinions can be considered. Madam Speaker, there are also questions or perceptions of unfairness. Some parties can perceive trial by a single judge as less fair or transparent compared to trials involving, let's say, multiple judges or a jury. And so that could also contribute to doubts in the impartiality of proceedings. Madam Speaker, my view is that whilst this is a step in the right direction, my preference would be that it would be a panel of 3 judges. Now, I understand and accept that that requires a great cost outlay and that could perhaps be resource intensive when you look at time and personnel. However, I believe it has some guarantees, such as a diverse perspective, greater checks and balances, consistency, uniformity, where the panel's judgments are subject to review and discussion among multiple judges, enhanced decision making. So this panel, judges would discuss, these discussions would allow for thorough consideration of complex legal issues and evidence, and judges can challenge each other's viewpoints, ask probing questions, and engage in robust debates, leading to more informed and well-reasoned decisions. Madam Speaker, I also believe that this would increase public confidence. This would increase public confidence in the judicial system. The involvement of multiple judges in the decision-making process will enhance public confidence in the fairness and impartiality of the judiciary. And I believe also the transparency of panel deliberations and the collective nature of the decision-making process will contribute to perceptions of accountability and legitimacy. As I said earlier, Madam Speaker, a panel would reduce the risk of error, and it would also ensure efficiency in complex cases. And these are cases involving intricate legal issues or significant precedents. You're looking at more efficiency and more effective means, I believe, of adjudication. And then, of course, Madam Speaker, there's the capacity for specialization. In some jurisdictions, you have specialized panels of judges that may be convened to hear cases in specific areas of law. For example, you have tax law, intellectual property, or international disputes. And so these specialized panels can leverage the expertise of judges with relevant backgrounds and training. And this would lead to more informed and nuanced decisions in specialized areas of law. Madam Speaker, those are my views as it relates to the bills today. I do not oppose the bills. I do think it's a start, but my views are that a panel will ensure more greater confidence than a single judge, given the circumstances and the reasons that I've laid out. Madam Speaker, those of us who have practiced at the criminal bar, I was in a conversation yesterday with a colleague of mine, and we were speaking about some of the issues lawyers, criminal lawyers on the defense side face in moving cases along. And I think should some of these issues be resolved, that would help to move cases along as well. So in moving cases along, Madam Speaker, legislation with respect to the government's or the prosecutorial arm's obligation to disclose information to criminal defendants in a timely manner. We should look at how best we could put these in place. You look at the United Kingdom, for example, they have a disclosure manual that guides how the Crown Prosecution Office fulfills its duty of disclosure of materials that they will use as well as unused materials to the defense. And these duties arise under statute and common law in the UK, and there are specific statutes and regulations that speak to it. But this manual, the disclosure manual that the Crown Prosecution Office Service in the UK is guided by, specifically gives the legal guidance on disclosure, how to disclose promptly, efficiently, and effectively, and how this can move cases along. So I believe, Madam Speaker, that disclosure should be spelled out and enshrined or codified, put in legislation, where comparative to that which is in the UK. So for example, you see in the United Kingdom, there's a Criminal Procedure and Investigations Act, 1996, Criminal Procedure and Investigations Act Regulations, 2011, Magistrate Court Rules, and the Covert Surveillance and Covert Human Intelligence Services Code of Practice. These all speak to, or these all seek to guide disclosure in criminal matters. The same applies in the UK to the Attorney General's guidance on disclosure, 2022, and of course, a 2013 protocol and good practice model on disclosure of information in cases, dated the 3rd of October, 2013. Madam Speaker, comparatively, in the United States, the Brady Rule refers to a legal principle established by the U.S. Supreme Court in the case of Brady versus Maryland. And this requires prosecutors to disclose all material and exculpatory evidence to the defense in criminal cases in a timely manner to defend, to affect, or to protect the rights of defendants, to ensure fairness in criminal proceedings, and of course to deter prosecutorial misconduct. I was told a story, Madam Speaker, about Sir Boyton Hall, former Chief Justice. And Sir Boyton Hall, I was told, once he was done with a case, when he was a prosecutor, once his case was over and the judge was summing up, Sir Boyton would sit down and read a book. And he said, look, I'm a Minister of Justice, no vested interest in the verdict, I've done my duty, and he moves on. And that's how it should be. Lawyers shouldn't be complaining about, and then when you look at disclosure, lawyers should not be complaining about the police prosecution arm saying, hey, the printer ain't working, so we can't copy the witness statements. We can't copy the docket and provide it to defense counsel or to a defendant. That is unacceptable. Okay, and I've heard of instances where in recent time that has been happening. So, Madam Speaker, I think we should move to address some of those issues as well to ensure that cases move ahead without there being a hold up with disclosure in pre-trial, in pre-trial reviews. And I think we should implement safeguards such as robust discovery rules, disclosure protocols, and training for prosecutors and law enforcement personnel, and then oversight mechanisms to ensure compliance with disclosure obligations. And that's other news that cultivates a culture of transparency and accountability and prevents non-disclosure. So, Madam Speaker, I support the bills today. I wish that they went a bit further in terms of a panel of judges, but nonetheless, this is a step in the right direction. Madam Speaker, Long Island rest.